I, the jury, in the trial of Plaintiff Jennifer versus Defendant AU Hospital. In this case, the plaintiff contends the hospital failed to determine that a reasonable effort was made to ensure she received notice of the request of her PHI. The plaintiff also contends the hospital failed to ensure that the party requesting the information made reasonable effort to secure a qualified protective order. According to www.hhs.gov, covered healthcare providers or healthcare plans may share your protective health information if it has a court order. This includes the order of an administrative tribunal. However, the provider or plan may only disclose the information specifically described in the order. According to the Privacy Act, C.F.R. 164.512E, when a court order is received, a covered entity such as hospitals may release records specifying with no further process required. However, in the case, the defendant stated that a subpoena was received by the hospital, but the defense did not state if it met the privacy requirements. The plaintiff attorney addressed the HIPAA privacy as well on the behalf of the plaintiff, which state providers or health plans may disclose information in the event of subpoena only if the notification requirements of Privacy Act are met. Before responding to the subpoena, the provider or plan must receive evidence that reasonable effort was met, such as 1. Notify the person who is the subject of the information being requested. 2. So the person has a chance to object to the disclosure. Or 3. Obtain a quality protective order for the information from the court. The defendant also stated that AU Hospital have a policy in place regarding sharing PHI and direct authorization, even though the hospital stated that they make numerous attempts to reach out to the plaintiff and was unsuccessful, but yet they still disclose the plaintiff information. If the hospital have a policy in place as well regarding PHI rights, why was the plaintiff notified? Why wasn't the plaintiff notified properly? Although the defendant for AU Hospital believed they did not do anything wrong because the requesting party was a government nature. However, because the defense failed to specify which type of government agent that was requesting the documents to support this defense, cite the 1974 Privacy Act and the exception of releasing information to either law enforcement, congressional investigators, or the Department of Homeland Security. The defense never stated that the government agency requesting the information was one of the three mentioned. It was not clear to me if the subpoena falls under one of the 12 Privacy Act's requirements. The defense also failed to state the purpose of the requester or the detailed information requested. Therefore, the defense failed to provide evidence that the subpoena received met both the HIPAA and Privacy Act requirements. The plaintiff attorney also addressed that her client was not contacted nor was she notified at any request for her to authorize release of her medical record. The plaintiff attorney listed in detail all the information that was included in her client record when the hospital released her records. When the plaintiff testified in the matter, she presented her feelings through voice and her emotions. As a patient, the hospital entrusted with patient care and responsibility for handling and protecting all healthcare information. The plaintiff clearly states in detail of the type of information was shared, such as phone number, address, and social security number. Because of this violation, the plaintiff no longer feels safe. However, the defense still argued that AU Hospital did no wrong. But yet, this apology to the plaintiff simply acknowledged some fault on their behalf. Therefore, I will have to find the defendant guilty as charged and rule in the favor of the plaintiff. Thank you.